Let's now talk about bankruptcy as a remedy for people that are potentially facing foreclosure or can't afford their mortgage payments. Now, I'm not a bankruptcy attorney per se, but I do know enough about bankruptcy to speak of it in general terms. Now, in bankruptcy, in my experience, it's usually not the best remedy for most of my clients, and I'm going to explain why in a moment. There's basically two types of bankruptcy for an individual. One is referred to as Chapter 7. A Chapter 7 is referred to as the liquidation chapter. So number one, you have to be able to qualify for a bankruptcy, and to qualify for a Chapter 7, you may have to have an income below a certain level. Now, in a Chapter 7 bankruptcy, you're basically, well, best thing to do is give a hypothetical. Let's say someone has $200,000 in debt, and they have $10,000 in non-exempt assets to their name. Well, if they file bankruptcy, you don't get a free ride. You have to give up the assets you have. Bankruptcy was designed to give you a fresh start, so that if you now make money in the future, you won't have to worry about a creditor taking it away. So if you have $10,000 in assets to your name, the bankruptcy trustee takes that $10,000. They liquidate it, and in this hypothetical that I'm giving, your creditors, who are $200,000 worth, would be paid 5 cents on the dollar, and then you wouldn't owe anybody anything, and you would be discharged, and you'd have a fresh start. Let's take this same example now and say someone has $100,000 in assets. Well, now they're not just giving up $10,000, they have to give up $100,000 in assets. Their creditors are now paid 50 cents on the dollar, and what I find is that you could have probably negotiated a better deal, a much better deal on your own outside of the bankruptcy. So bankruptcy can be a good remedy for some, but in my experience, if a person has assets, they're going to have to give that up in a bankruptcy. If they don't have assets, then bankruptcy may be a good remedy, except the creditor probably isn't going to pursue you for collection anyways if you don't have assets. They're probably going to write it off as a bad debt. And if that's the case, if it was your primary residence, or if you're considered insolvent, you wouldn't be responsible for paying any taxes if you received a 1099. So really, what was the purpose of filing a bankruptcy if no one's going to go after you? Now, a Chapter 13 is not much difference, except that in a Chapter 13, they don't take any assets away from you. They figure out your assets, and you either pay your creditors back in full or the equivalent of what they would have received in had you filed a Chapter 7. So let's go back to our example. The person has $10,000 in assets to their name. They owe $200,000 to creditors. So now the trustee wouldn't take away that $10,000. Now what would happen is you would submit a plan to the bankruptcy court to pay back the equivalent of what the creditors would have received in a Chapter 7. So now you'll have to make payment arrangements to pay $10,000 in cash over a 36 to 60 month period of time. So again, not so bad, except you're now going to have a bankruptcy on your credit history. And if the creditor wasn't going to pursue you in the first place, there was really no need to file bankruptcy. You could have avoided potentially a foreclosure, and you didn't have anyone coming after you, so the debt that you got rid of in bankruptcy and had to pay $10,000 for, you might have gotten rid of for free had you not filed bankruptcy. Now, bankruptcy attorneys earn their living by filing bankruptcy for clients, so my experience is most of them are going to push you towards bankruptcy because that will help you. But if the lender writes it off, and if you're not responsible for the taxes, not only did you not need to file bankruptcy, but if you waited, and let's say in the unlikely event the lender did pursue you for collection, you could always file bankruptcy at that time. Bankruptcy is never off the table. So you could, in a sense, have two bites of the apple. Wait and see if the lender just writes it off as a bad debt. And if they don't write it off as a bad debt, you can always file bankruptcy if they pursued you for collection. Now, let's say you're someone that fits in that second category. You have, instead of $10,000, $100,000, and you owe your creditors $200,000. Well, now, if you file bankruptcy, you have to give up too much in a bankruptcy, in my opinion, to make it worthwhile to file. You'd be better off doing some asset planning to make it difficult for your creditors to collect, and then try and negotiate with your creditor, so either they just wrote it off as a bad debt, or sometimes, in my experience, we've been very successful settling with lenders for pennies on the dollar on a deficiency, where if you filed bankruptcy, in this hypothetical, you'd have to give up 50 cents on the dollar. We might have been able to settle that for 5 or 10 cents on the dollar. So bankruptcy can be a good remedy for those who have other types of debt, like if you have massive credit card debt or hospital debt, or there are other reasons for a bankruptcy. I'm not ruling that out as an option, but for most people that are just have a foreclosure that they're facing, there are better remedies than bankruptcy, and bankruptcy can always be used as a remedy if all else fails.